Hello, my name is Matt Tuff. I am a Senior Associate in the Major Trauma Department at Moore Barlow. Today I'm going to be talking to you about the issue of mental capacity following a traumatic brain injury. Now, after a moderate or severe traumatic brain injury, it's not uncommon for a person to demonstrate cognitive defects, such as impaired memory and concentration, difficulties processing new information, and a reduced ability to plan or solve problems. A brain injury survivor may also lack what's called mental capacity, which is defined as the ability to make a decision in relation to a particular matter because of an impairment or disturbance in the functioning of the brain or mind. Now, in the early stages after a significant traumatic brain injury, a person may also have what's called post-traumatic amnesia, or PTA. Now, that's a state where a person is unable to form continuous memories. For example, they may forget what happened to them the day before, or even earlier the same day. They may exhibit confusion or agitation. They may be unable to understand why they're in hospital, or may lack insight into their injury and how serious it is. During this period, it's likely that they would lack capacity to make important decisions. However, even after they've recovered from the PTA, which may tend to be a few weeks, they may still lack capacity to make decisions. The question of mental capacity could be described as issue specific. In other words, a person may have capacity to make a decision on one matter or issue, but not on another one. A person lacks capacity in relation to a particular issue if they are unable to make a decision due to an inability to understand the information relevant to the decision, to retain the information long enough for the purpose of reaching the decision, to weigh up the information relevant to the decision, or to communicate their decision by any means. Now, the most important piece of legislation on this area is the Mental Capacity Act 2005. This act, amongst other things, establishes a number of important principles, including the following. The first one is a person must be assumed to have capacity unless it's clearly established that they lack capacity. For example, you can't merely assume that just because someone has a significant brain injury that they do lack capacity. A person is not to be treated as unable to make a decision unless practicable steps to help them to do so have been taken without success. Another principle is that a person is not to be treated as unable to make a decision merely because they've made an unwise decision. So, for example, because they bought something quite expensive online or something like that. Another principle is that an act done or decision made for a person who lacks capacity must be done or made in their best interests. At Moore Barlow, we often have clients who, because of their acquired brain injury, may not have capacity to conduct the litigation, so the capacity to understand the advice of their solicitor and to make decisions based on that advice, and clients who may not have capacity to manage their financial affairs. So, one question is, what steps can be taken to assist people who may lack capacity? So, where a person lacks capacity to conduct the litigation, someone called a litigation friend needs to be appointed. This is someone who assists them with making decisions in relation to the legal case, and it's often a family member or close friend. Where a person lacks the capacity to manage their financial affairs, an application needs to be made to the Court of Protection to appoint someone called a deputy. This is a person appointed by the court to make decisions for the brain injury survivor about their finances and property. A deputy is often a professional, maybe a solicitor, but they can be a family member. A deputy should work closely with the client and, where at all possible, help them to participate in making decisions. As regards capacity to manage finances, a brain injury can cause a person to lose inhibition and act impulsively. It can create vulnerability. The brain injury survivor may be susceptible to making regular, impulsive or irrational purchases. They may be vulnerable to people who would seek to take advantage of them or to persuade them to part with their compensation. Having a deputy who is subject to the oversight of the Court of Protection helps protect against these risks. Now, where a person lacks capacity to conduct the litigation, no settlement of the personal injury claim can be reached unless a court has been asked to approve the settlement. The purpose of this is to protect the interests of people who do not have capacity to make decisions for themselves. Obtaining court approval involves a relatively informal court hearing. At Moore Barlow, we regularly assist people who, as a result of their brain injury, lack mental capacity. If you have any questions on this topic, please don't hesitate to contact me, Matt Tuff, at Moore Barlow.